Hello, YouTube. This is Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. It is Friday afternoon, and I will be going live in about 40 minutes for 1 to 2 hours. But I've got to get my Monday video up. So we have a question here from YouTube user Henry Best Believe, which is a great username. And Henry Best Believe asked us, do you always ask for attorney fees at trial? How about in settlement? When would you not ask for them? So, in terms of asking for attorney's fees at trial, you ask for them at any point that you think there's any realistic chance that you will obtain them, right? Certain laws have provisions for attorney's fees. Others do not. Certain jurisdictions and courts offer provisions for attorney's fees with different sorts of claims. As long as you are litigating a workplace discrimination or workplace sexual harassment case under the federal laws, if you go to trial and you win at trial, you would functionally always make some kind of application for attorney's fees. Always, under the federal laws. Now, almost. There's always an exception that proves the rule, so we'll say almost always. 99 out of 100 times you make an application for attorney's fees if you win at trial with a workplace discrimination or workplace sexual harassment case. Now, the second part of your question is, would you ask for attorney's fees in settlement? Almost never, unless your client really wants to phrase it that way. And here's why. It's not a relevant talking point. And immediately I can hear people like pulling up to their keyboard, ready to type away and tell me I'm wrong. Give me a minute. In settlement, you are asking for the sum that you believe you might be able to win at trial, adjusted downward to account for risk and the opportunity cost and the time and effort that it would take you to litigate the case all the way through trial, right? So you're taking into account that you might not win at trial. You're taking into account that there's various stages of motion practice where things could go badly for you. You're taking into account there's risks in discovery. You might not get the things you want in discovery, or discovery might not go your way. There might be secret documents that you didn't know about that tank your case, right? So the settlement figure is always going to be some version of you hedging for risk and opportunity cost and taking less than you might have won. Now, you can always make any settlement demand you want as long as it's legitimate, like something you could win, right? Has to be legal. It has to be something you could win. Beyond that, there's not a lot of constraints in terms of what you ask for in settlement. So you can say, let's say you believe you're going to win $1 million legitimately at trial. You think those are your damages, your economic damages, your emotional damages, maybe your punitive damages, right? And you think you're going to win 6 out of 10 times. So you ask for $600,000. And then you say, on top of that, I'd like $200,000 in attorney's fees. Two things happen. One, the defendant's going to say, well, part of why we're settling with you is so we don't have to run the risk of attorney's fees, right? Like we don't want you to take this to trial and potentially win $1 million, but we do note that even though we want to settle with you, we think if you win this, you probably don't win $1 million, at least not all the time. On top of that, we also, if you win, don't want you to make an attorney's fee application because that attorney's fee application could be sizable. And we think, while it might be unlikely that you actually win the $1 million that you believe you're going to win, we actually do think your attorneys might have success with a sizable attorney fee application. A sizable lodestar application would be the old way to say it. And we don't want to face that, right? We think if you win, you'll probably win $500,000, right? We just don't agree with your numbers. We think your numbers are bullshit. But if you win that $500,000, we fear that your attorneys might win a lodestar, an attorney fee application for $350,000, $400,000, which gets us right back up to that million, pretty close to that $1 million, right? So that's part of what we're settling for now. So they're not going to be pumped about it. Your attorney will be very pumped about it. I mean, not realistically, because the attorney's going to be like, they're not going to do that. They'd have to be stupid to do that. But the other side of that coin is, if you're making that demand, your attorney's going to be like, listen, if you get attorney's fees and settlement, I still get my percentage of that, right? Example. And listen, every retainer is different, but this is the standard. I don't think I've ever seen a retainer that would treat this differently. So just, look at your retainer. Things can be different for whatever your arrangement is with your attorney is what your arrangement is. But the standard that I tend to see in this field would be as follows. Let's say you take a settlement of $600,000, $500,000 in your case, and you get an additional $500,000 in attorney's fees in settlement. Well, one, I applaud you. You got attorney's fees and settlement. So you must have moved heaven and earth. You must have really had a lot of leverage. The defendants must have been wild to get this case off their books or not go to trial, whatever it is, right? Like they had to have a really good reason to give you attorney's fees. They essentially paid you 100 cents on the dollar on this case that you believe you could win for $1 million. They must have agreed and thought that you win it 10 out of 10 times, right? Which is unlikely in the scheme of things. There's no 10 out of 10 case. There's no sure thing in this industry. But your attorney's sitting there saying, I am so glad that we won $1 million in settlement. I got you $1 million in settlement. You're like, well, no, you got me $500,000 and I got $500,000 in attorney's fees. Your attorney's going to say, I mean, $1 million's $1 million. I got you $1 million in settlement, of which I will take my percentage. So like, let's just go with like the old percentage, like 33%. That attorney is going to pocket $333,000 of that $1 million, right? The 500 attorney's fees, 500 of your actual settlement. It's all money the attorney achieved for you in settlement. So they're not going to be like, well, I'm going to take my fee on the 500 grand attorney's fees. Like that's not something that exists in our retainer agreement, in any retainer agreement that I've ever seen, as I noted. Now, you might not like that. Negotiate it on the way in, right? Nobody's making the retainer agreement where they exempt out attorney's fees and settlement because immediately the plaintiff will say, I'd like a settlement of $500,000 in attorney's fees. I'm not worried about economic damages. I'm not worried about emotional damages. I'm not worried about punitive damages. I only want my attorney's fees. $500,000, please. I'm sorry we only got attorney's fees and settlement, my counsel, but that means you get nothing. It's how the cookie crumbles. Yeah, that's what people would immediately try to do. I'm sure somebody's already tried to do it. And I'm sure some really stupid attorney might have fallen for it at some point. But I'll tell you right now, no attorney with any experience in this field is ever going to tinker with a fee arrangement in that way, because immediately they'd be sitting here like, no, I'd have to be stupid to do that. You're just going to try to characterize the settlement, because the defense doesn't care what you characterize the settlement as. And the defense is going to say, wait, you're telling me you don't have to pay your attorney if I call this attorney's fees? Good, because your attorney's the thorn in my side. And sounds like I can give you 33% less and you don't actually care because you're not going to pay this attorney a goddamn red cent. So let's cut a deal, right? And they're going to be super pumped about that for obvious reasons. And you as the plaintiff are going to be like, well, no, you can't cut it by 33%, but you can take 10% off and I'll still come out ahead. So like, yeah, we'll both benefit by cutting my attorney out of the deal, right? So it's very unlikely that any attorney is going to cut that retainer for you. If they do, and if there's not some very clever protections built into that agreement, am I going to sneeze? Excuse me. If there's not some very clever protections built into that agreement, your attorney may have just cut a significantly stupid retainer agreement, which may cause you to ask questions about the intelligence level and the competency of your attorney. I would not necessarily be impressed with that attorney, in all honesty, right? So there's significant issues with attorney's fees in settlement. That's generally not going to, you can call it anything you want, but like it's kind of irrelevant. It's just tacking words on at that point. Like the things that really add up in settlement talks are economic damages and emotional damages. And you can use punitive damages as leverage in settlement talks. But attorney's fees are kind of like a non-starter. Everybody will just be like, I mean, we can call it that if you want. Whatever floats the plaintiff's boat. Nobody cares, right? Like it's the same amount of money. So you have X amount of leverage. We're willing to give you X amount of dollars. You can call it things. You can call it the Banana Republic Fund. You can call it the company, not the political institution, right? Like you can call it the gin budget, the Hendricks and Tonic budget. Like, you can call it anything you want. Like it's nobody cares. It's just kind of irrelevant. It's the Sunflower Fund. We like sunflowers. They're delicious. All right. Anyways, Henry, best believe. I hope all is well. You have a beautiful puppy in your profile graphic there. Perhaps not a puppy any longer. It's hard to tell. It's very small, but it's a beautiful dog. Beautiful pupper. Like, subscribe, comment down below if this was helpful. If it was, share the channel so it may grow. I have fulfilled my contractual obligations. I will not be scolded. Take care, everybody.